The ANC arrived charged with energy at the South Gauteng High Court, where their application of no confidence against Johannesburg Mayor Herman Mashaba and Council Speaker Vasco da Gama was to be heard.
We are asking the court today to make sure that those two motions are put on the council roll for tomorrow. In terms of a secret ballot, which we are also asking the court to declare to the speaker that he's got the right to make sure that this voting on these motions is carried through a secret ballot. Mayor Mashaba is just buying time in order to have another day in office.
The ANC's application was detailed and lengthy, citing many examples from previous judgments, such as the UDM secret ballot case that ended up in Constitutional Court.
What we have referred to is indeed then the Constitutional Court judgments in Mazibuko and the UDM, where the Constitutional Court did not find the source of the power for the Speaker to exercise his discretion in the rules per se, but found the answer in the Constitution itself.
Advocates representing the defendants managed to present a case that strongly proved that the application was not urgent and that it should never have reached the inside of a courtroom.
That elephant, why can it not be resolved by a court of law in the next 8 weeks? It took the highest court of this land, with 11 judges, my lord, about 5 weeks to determine the secret ballot matter.
In the result, I make the following order. 1. The applicant's application is struck off the roll for lack of urgency. 2. The applicants are ordered to pay the first and 18th respondents' costs, including the costs consequent upon the employment of 2 counsel. I accordingly hand down the order.
Well, the ANC notes the judgment by the court to strike the matter off the roll. And the striking of the matter from the roll doesn't necessarily mean that the merits of the case presented before court do not hold water. We still believe that the decision by the Speaker to refuse to allow the motions to be placed on the council agenda for 27 September is unlawful and unconstitutional. We are convinced that the rights of councillors to present such motions of no confidence on both the mayor and the speaker have been trampled upon by the speaker. So we will be approaching the Constitutional Court on an urgent basis to get the court to hear the matter.
And we see this as an opportunity to reaffirm our commitment to fighting corruption in the city of Johannesburg. We believe that this has been a smokescreen by the ANC to try and regain power in the city to continue their looting. We do believe that the court's time has been wasted today. This was not an urgent application. We welcome a motion of no confidence. We had to object to this because we are abiding by the standing rules of council. These are rules that were passed by the ANC when they were in government. Our rules are very different to that of the National Assembly, and the public must understand that. National Assembly clearly provides the Speaker with a discretionary power to determine how that vote should take place. The rules for the city of Johannesburg do not have such a provision. We state exactly how a vote should take place in council, and that is in an open manner. We are ready to defend this matter in any court. We find it quite concerning that they would immediately jump to the Constitutional Court when it has been so clear from today's proceedings that there is no urgency in this matter.